Start. This is statutory provisions. Stop. This is inherent philosophy in the policy of the motion of no confidence. Stop. Election for 5 years does not mean that the elected representative has got blanket power to move on his oblique her own way without taking care of public interest. Stop. Persons holding public office as a leader of elected body are elected to discharge public obligation and can continue till the confidence reposed in them by the people. Stop para. The full bench in Vikas Trivedi under bracket Supra having noted the above observations of the division bench has put a note of caution that all provisions of the statute are required to be complied with and there is no discretion in the authorities and they are not free to disregard the provisions of statute to carry out no confidence motion at their whims. Stop. The question before the full bench was, however, with regard to the mandatory or directory nature of the prescribed procedure, the requirement of giving notice by the collector under section 15 under bracket 3 under bracket second in the prescribed form as required by the rule. Stop para. The above noted observations about the import of section 15 of the 1961 Act, are relevant to understand that the provisions of section 15 are procedural provisions and the right to carry out a motion of no confidence brought by the elected members against the Pramukh of Kshetra Panchayat has to be exercised within the framework of the statute. Stop. The statutory provisions are to be followed strictly. Stop para. We may further note that while subsection under bracket 1 of section 15 confers statutory right upon the elected members of Kshetra Panchayat to bring a motion expressing want of confidence in the Pramukh of a Kshetra Panchayat, the said right is curtailed by subsection under bracket 13 of section 15 itself, which provides a caveat that no notice of motion under section 15 shall be received within the time prescribed therein of the assumption of office by the Pramukh. Staff. This time period prescribed in subsection under bracket 13, which was 1 year, has been substituted by ordinance number 8 of 2022 with effect from 4/10/2022 to 2 years of the assumption of office by a Pramukh. Staff. The collector concerned is, thus, prohibited from receiving a motion expressing want of confidence in a Pramukh of Kshetra Panchayat within 2 years of his assumption of office since the date of enforcement of the amendment, which is 4/10/2022. Stop. Para. The dispute is that whether the substitution of words quote 2 years D quote in place of quote 1 year D quote would operate prospectively or retrospectively. Stop. The argument of learned counsels for the petitioners is that once the motion of no confidence has been received by the collector, having been moved by the elected members in accordance with the provisions of subsections under bracket 1 and under bracket 2 of section 15, there was no option before the collector but to proceed, to carry out the motion, in accordance with the provisions of subsections under bracket 5 to under bracket 11 of section 15 comma as the date fixed by the collector comma after scrutiny of the written motion start.